Is Tom present at the meeting in person?
Yes, I'm here.
Okay, there he is. Okay, great.
Chair Meyer, we are ready to start the meeting and call the meeting to order when you are.
All right, good morning. Agenda item number 1 is call to order. It's 9:30 a.m. on April 27th of 2023. My name is Damian Meyer. I'm the chairperson. I'm calling this meeting of the Citizens Clean Elections Commission order. I'd like to ask audience members to please keep their microphones on mute if you're appearing by Zoom. And with that, we will take attendance. Commissioners, please identify yourselves for the record. And let's start with those that are there in person.
I'm Galen Payton. And I'm Mark Kimball.
And then do we have anyone appearing by Zoom? Please identify yourself.
Hi, Chairman Meyer.
Yeah.
Oh, sorry, Mr. Titla. Go ahead.
No, go ahead. Go ahead.
Thank you. Amy Chan appearing virtually, and I apologize. I'm not sharing my camera today because I'm really feeling under the weather. So, but I'm here.
Well, I'm sorry to hear that. I hope you feel better soon. And then I think Commissioner Titla, you're here as well.
Yes, sir. Steve Titla here. Thank you.
All right, thank you. All right, so we have all 5 commissioners in attendance. And with that, we'll move on to agenda item number 2, which is discussion and possible action on meeting minutes for March 23 of 2023. Any discussion? And if not, can I have a motion to approve the minutes?
Mr. Chairman,
Commissioner Kimball,
I move we approve the minutes for the March 23rd, 2023 meeting.
is there a second?
I'll second it. Galen Payton.
All right, we have a motion and a second to approve the meeting minutes for March 23, 2023. We will go ahead and vote. We'll call the roll, and I'll start with Commissioner Chan. How do you vote?
I vote aye.
Commissioner Titla,
I vote aye. Thank you.
Commissioner Payton,
Aye.
and Commissioner Kimball.
Aye.
All right, I'm going to abstain because I wasn't there, but it passes 4-0 with 1 abstention. Moving on to agenda item number 3, which is to discuss some possible action on executive director's report. Tom, take it away.
Thank you, Mr. Chairman, members. Thank you all for being here with all of our. I know there's a lot of stuff going around, so I'm glad everybody was able to make it. Just wanted to quickly, mention you've received over the course of the last couple, over the course of the session, Mike's updates on the legislative activity. I wanted to mention up front, the legislature, I think, is going to be on a little bit of a break here now, and then they'll come back. Eventually, they'll have to get together on a budget. That's really the main thing left. There's not really very much election legislation left out there. So we'll be seeing if they resolve a budget here sometime in the next, the next month or so. We have 2, 3, or 4 rather local elections going on right now, including in the city of Tempe and the city of Tucson. These are all ballot by mail elections. That basically means that everyone who's eligible to vote has gotten sent a ballot in the mail, and those elections end on May 16th. I wanted to highlight a couple really quickly, just a couple of things that in voter education and outreach. Avery did a presentation at the Pasteur Center at ASU on how to run for public office. I thought that was really good. We got some really good feedback and questions from that. And also, he recently met with the city librarian in Tempe, and I think that that's a good opportunity to flesh out, working with those kinds of public resources. And then obviously wanted to highlight that Gina worked with did a presentation to some 30 visitors from around the world as part of the Global Ties Council for International Exchange. She was one of several officials with the state and county, including a number of high-profile elected officials who met with this delegation. So it's really exciting that she was included in that and was able to participate in that. There's some administrative stuff happening. Nothing really, no big changes since then, although the governor's bipartisan election task force has started to meet. There's still some ongoing legal action, including stuff related to the 2022 election that hopefully will get resolved here in the next month or so. Those are really sort of the principal. Those are really the principal things that are happening right now. And we do have, I just want to note really quickly, we will have an oral argument in one of the Prop 211 cases on May 12th. So if you're interested in attending that or finding out more about that, this is on a case brought by some plaintiffs in state court that principally concerns the state constitution. If you want to find out more about how you might attend or get updated on that, please let me know, and we'll put that together. That pretty much completes my report. So thank you, Mr. Chairman and Commissioner.
Thank you, Tom. Hey, can you tell us a little bit more about the bipartisan election task force, and who's that composed of, and what is its mission, if you will?
So the bipartisan elections task force was created by an executive order, I want to say in January, and then sometime in late last month, I want to say maybe late February, the governor named the members. The members by virtue of the order include county recorders, experts in campaign finance, experts in voter outreach, members who represents the disability community. And so the prior executive director's report has a list of the members, but the members range from, the Pima County recorder to retired Maricopa County former Maricopa County recorder Helen Purcell, to the Secretary of State Adrian Fontes, a rural recorder Ronaldo Fowler, who many of us know is on our debate work group and a longtime partner with the voter education here, represents the disability community on it. There are a couple of legislators. Senator Ken Bennett, who's a former Secretary of State, is on it, as well as a new representative named Laura Tarek. So it's the goal is to have it report in November. The executive order is fairly broad to look for ways to sort of improve the election system in general. We probably won't get a firm sense of what their focus is until the next meeting or the meeting after that, whenever that is. The first meeting was not open to the public. So we'll see if they decide to open those up or not. They're not required to. The governor is, as a single elected official, is not necessarily obligated to, have filed the open meeting law in terms of the way we do, because it's not a multi-member board, it's the governor's office. So, but they have a broad mandate basically to find ways to improve elections, improve participation in elections. And then they're supposed to report in November. So we, although obviously we're not direct participants, but we're members of the executive branch. So, obviously we'll pay attention to it. And certainly if anybody from the task force ends up having questions for us, we're ready to provide, answers to them. I'm not sure that they will. I really think that the upshot is more on focusing on improvements to the election process itself. So that's pretty much, that would be my best summary, I think.
Thank you, Tom. Any other commissioners have any questions? Okay, seeing none or hearing none, we'll move on to agenda item number 4, which is to discuss and possible action debates work group. As you may recall, the commission authorized a debates work group to bring stakeholders together to discuss and review our debate program. Commissioner Kimball has chaired 3 meetings of the work group, working in conjunction with Gina and other staff. Gina is available via Zoom to give us a status report. Any questions, or I guess Gina, go with your status report and then we'll follow up with any questions.
Thank you, Mr. Chairman, commissioners. Good morning. Yes, I have just a brief update for you on the progress that the candidate debates work group has made so far. So to date, we have had 3 public meetings. They are open to the public and they are streamed on our YouTube channel, basically the exact same process that we have for our commission meetings. And the work group has had some really great discussions. So far, the agenda items have included what makes a successful debate from the perspective of a candidate and a voter. We've discussed the format and structure of our debates, including possibly restructuring them so that they are conducted by party and by chamber. And then we have had discussions on best practices for voter education for debates. We've also discussed the rules during the debate, such as the rules of engagement for the candidates. We are very excited that our next meeting, which is May 3rd, we will have a special guest speaker who is actually the executive director for the Presidential Commission on Debates, Janet H. Brown. Ms. Brown, she's an American political executive. She's a former government official. She's served as the executive director since the founding, actually, of the Commission on Presidential Debates in 1987. And she's worked at the White House before, the Office of Management and Budget, the Department of State. She's worked for the United States Senate. And so she has quite the wealth of information and knowledge when it comes to dealing with candidates and to the debate process. And so we are very grateful for her time that she's agreed to present to our work group to talk about some of the successes that they have seen over the years in executing presidential debates and also some of the challenges. So we think that will be a very insightful discussion for our work group members as they continue to meet and discuss best practices for the clean elections debate process. After May 3rd, we have our final meeting and at the end of May, and that will wrap up the meetings of the debate work group. And so we hope to come before the commission with any recommendations that the debate work group will make in the summertime after that.
Thank you. Commissioner Kimball, anything to add since you've been leading the group?
Well, when we started with this, I was somewhat leery because it's a very large group. But I've been very impressed with a number of the participants who have had some excellent suggestions on how to update the debate process, which has essentially been unchanged for several decades. We have a very interesting group. We've got some journalists on there. We've got some political people, political advisors. We have some former elected officials. So there's various members of civic groups. So there's a really good mix of people, and I think we'll come up with some very good suggestions. And I can't stress enough how much Gina and Avery have made this work, and they've really done a lot of work in explaining the way our current debate system works, and then leading discussions on where we might want to consider some changes. So I'm very pleased with how it's going so far, Mr. Chairman.
Thank you. Any other questions from the other commissioners?
I had a question for Gina. This is Commissioner Payton. So you said something about debates by party and by chamber. Can you explain what that really means?
Mr. Chairman, Commissioner Payton, commissioners, yes. So part of the agenda item for the work group included discussion of the overall format and structure of our debates. So currently, we host one debate per evening. So for example, on a Wednesday evening at 6 p.m., we would hold a debate for Legislative District 1. And what that would include is every candidate that's eligible to debate, so every candidate whose name is on the ballot and who is in a contested election would appear in that one segment, that one debate. So that means we would have Senate candidates, we would have House candidates, we would have Republicans, we would have Democrats. They would all be together and they would all be part of that one single debate. And so there was discussion on having that particular format. Is that truly a debate between the true opponents? So does that truly mean that the Republican Senate candidate truly gets to debate only their Republican Senate opponent in a primary election, for an example? So the discussion was, how can we format and restructure the event to ensure that we truly have that debate between the true candidates? And so what the debate work group has approved to include in its official recommendation that will be coming before the commission to consider is continuing with one event per evening. So again, it would be Wednesday, 6 p.m. LD1, but the run of show, the format and how we progress would be let's say the first 30 minutes of just those two Republican Senate candidates talking. Then we would transition into the next group of opponents and then transition into the next group of opponents. And with that comes the acknowledgement of, we would really need that we have that programming and that timing publicly available, so voters understood again that run of show, and that way they knew when to tune in if they wanted to see two particular candidates. But it ultimately came down that they felt it would be a better experience for the candidates so that they could focus directly on their opponents, but also a better experience for the voters so that they could truly see the differences between the opponents and between the true selections that they get to make on their ballot. So ultimately, it just comes down to ensuring that during our single event, we are structuring it in a way so that the opponents get to debate one another directly, as opposed to having all candidates within that particular district talk back and forth.
So does that mean for a shorter period of time, the two debate, and then when they're done, then you go on to the other group or the other chamber or whatever?
Mr. Chairman, Commissioner Payton and commissioners, we would have to, so the ultimate goal, and this includes something that the debate work group has also confirmed, is that it would always be our goal to ensure that candidates have equity when it comes to speaking time, and that there's near equal speaking time and opportunities for speaking time for all candidates. So we would have to really focus on the programming. So each district would obviously be different depending on who qualifies for the ballot and who's eligible to participate in that debate, whether or not they have a contested election. So once we go through and we know and we confirm who has made the ballot and who's eligible to participate in our debate, we would have to, as staff, work closely with our moderators to make that program, to identify, okay, we have X number of candidates who are eligible to participate, and then this is how we're going to split up the time to ensure that it's near equal speaking time. Now, how does that compare to speaking time to our current process? I believe it would be near equal because we would still have the same number of candidates. And so, that itself wouldn't change. It's just how how the moderator calls on each candidate to interact with each other. So I don't think we would see a significant issue where we would be shortening speaking time for candidates. It's really just going to come down to programming and managing that time once we know which candidates are eligible to participate.
Okay, thank you. That kind of clarified things in my mind. And I've been to the debates where, there's representatives and then there's a senator, and it seems like it's like a 3-ring circus at times. So I understand now. Thank you.
Thank you, Commissioner Payton. Any other questions? Okay, thank you for that report. We'll move on to agenda item number 5, which is discussion and possible action on Proposition 211, the Voters' Right to Know Act, including litigation and staff research. At the last meeting, staff began a series of presentations taking a more in-depth look at Proposition 211 with an eye toward implementing the regulatory agenda that this new act requires. Today, we're going to drill down the mechanics of reporting and exemptions of reporting, as well as disclaimers on advertising and the new proposition requires. Tom, go ahead and take it from here, please.
Thank you, Mr. Chairman and Commissioners. So you have in your packet, and then we're going to have, I think, on the screen for those watching, PowerPoint. This is the second sort of edition of this same PowerPoint, and as Chairman Meyer said, we're gonna focus on a little bit different, and we're gonna do a recap of what we talked about. So I guess if we could go to the next slide, page 2. So,
and this is agenda item 5, the attachment for agenda item 5 in the packet.
Yes, that's correct. So I wanted to start again with the ballot language, because as we think through this, the ballot language, the yes vote, really is sort of a good guide to what we're talking about, right? You've got this additional disclosures for campaign media spending at certain levels. You've got to identify these original contributions of more than $5,000. There are civil penalties, and then there's this rulemaking process. So today we're really going to be on, in part, or for the most part, although we'll talk about a couple of the things, that identifying original donors of contributions of more than $5,000 in aggregate part. So, but I wanted to recap, if we could go to slide 3, some of the key provisions we talked about last time. So, and this is important to just kind of bear in mind. So the one of the first key provision of the new act is it defines campaign media spending. And what campaign media spending encompasses is expenditures for candidate elections, referendums and initiatives, recalls, partisan campaign activities, and then some related exceptions. And then there are expenses, right? And then there are exceptions for nonpartisan voter registration activities, and news gathering and books and those kinds of things. So, those are, for traditional campaign finance disclosures, those are the kinds of things that are covered. In Arizona, prior to 2016, that was pretty much how it worked. And then there was an act that passed that kind of narrowed what was going to be required, and then this sort of brings this back out in terms of the universe of things that we're going to be looking at as far as where people are spending money. It also defines what a public communication is, right? So that means it's setting a definition of when you're speaking with the public, as opposed to, for example, if you're sending a newsletter to your members, or something like that. So those internal communications, and again, that's very consistent with, traditional campaign finance rules. It sets 2 different thresholds for filers, one at the statewide level, one at every other level. So $50,000 of the statewide is the trigger for the first report for a statewide election under any of those categories where you do that much campaign media spending. 25,000 if it's a city basically, or a county or something like that. And then the commission has the authority to adjust those for inflation. Real quick note, and you'll see this term reused throughout this presentation. Persons required to file are called covered persons. So as awkward as that is to say, that's the parlance you're gonna see. And what that basically means is a covered person is a person who's covered by the act. The reports that they file are first required within 5 days of meeting that $50,000 or $25,000 threshold, and they include the spending and identity of each donor who contributed more than $5,000, as well as intermediaries. Donors have to be informed of the right to opt out of their money being used for campaign media spending, and the commission has explicit authority to make the rules on what that disclosure, what that opt-out language looks like. And then, and I mentioned this because it will be an issue we'll have to deal with in the rulemaking. There's a provision that talks about preventing structuring of transactions to avoid reporting. That that provision eventually, we talked about that last time, and we'll talk about that more in the future as part of the rulemaking extra. So that's really what we covered in March. I don't know if I guess I may as well pause here just in case there's anybody who wants to follow up on any of those things specifically before we kind of move into the meat of this presentation.
And so this starts, excuse me, Mr. Chairman,
Yeah.
Go ahead.
I have a question. So this starts at what election?
Mr. Chairman, Commissioner Payton, so the law is in effect now. So especially for opt-out purposes, if folks are raising money right now and they want to use that money for campaign media spending, they ought to be providing that opt-out. And the language of the statute provides the guidance for what the opt-out is. It also says the commission can make additional rules, but there is a basic outline of what that information is that is clear, and people have, and we know for a fact that people have in fact provided that to voters or to donors. As far as reporting goes, the reality is that we have two different components that will, so the act is in place, but the enforcement aspect of it really hinges upon the reports themselves, right? So, and there's two components to that. The first component, and probably the driver in some ways of this, is going to be the technological aspect of it. So this act, like the prior campaign finance acts in the state, requires the filing to be with the Secretary of State's office, and requires that the Secretary of State's office essentially develop the software to provide for the filing. That's something we've been in some discussions with the Secretary of State's office on, and we're hopeful that we will get there before January, is what we have told the courts and what we've told the stakeholders.
So do they have the technology to do that, Tom?
Mr. Chairman, Commissioner Payton, the issue is, I mean, there's a couple of different issues. One, the technology itself is not sort of revolutionary. The real issue is just the grunt work of coding in the information and then running that through the tests. I think that one decision that the Secretary's office will probably have to make is what kind of vendor they want to work on this, and then there's a separate decision about how they want this to integrate with the current filing system. In other words, I think that every secretary for the last decade has said we would like to make improvements to the underlying filing system that has been in place since basically since the Clean Elections Act was originally passed. And every secretary has made incremental improvements to that at varying increments. So I think there's a couple of decision points that they'll face, and you know, one, identifying who they want to do the work, and then two, how they want to scope it in terms of ensuring that the folks who are you know, that, for example, and we'll get into where the traditional filers and the filing requirements of this act overlap in this presentation, but you know, there's a conceivable way where you could build a system that just does Prop 211, right? You could just say, if you have Prop 211 filings to make, you make them here, and this is how you do them. That's what, for example, the city of Phoenix has a ordinance that's very similar to Prop 211, and we'll see later in this a little bit what their form looks like that you fill out online. That's what they have. So if you go to the city of Phoenix's campaign finance website, if you want to see you know, candidate filings, you go to, they have a thing that says candidate filings, and if you want to see that, they call it their dark money ordinance or something like that, and it says dark money ordinance filings, and you go there. So there's different models they could use. You know, I'm agnostic personally on how they do that, obviously, because I'm not a tech person, but you know, our main goal is to hope, and what we've told the stakeholders and the courts is that we hope this would be online by January, to allow for reports through the 2024 election, because we think that the 2024 election, from an initiative standpoint, referendum standpoint, and legislative standpoint, at a minimum, is one where, you know, we think this information, the voters want it, and that it will be valuable on those fronts.
And another question, how does the court, I mean, these lawsuits, how do these enter in? And obviously they can be a monkey wrench
Right.
into the whole apparatus. I mean, how soon is that going to be? I mean, I know you don't have a crystal ball, but.
Well, sure. No, ma'am. Mr. Chairman, if I may, I mean, we have, you know, one of our attorneys, a couple of our attorneys who are working on those cases available, but I would say this, that we have this oral argument, as I mentioned earlier, in May 12th in the state case. So there's two, and then we have, we're not at that place where we have any of those argument dates set in the federal case. The one difference between the state and federal case as they stand now is the state plaintiffs are seeking a preliminary injunction, which is designed to, you know, stop the implementation of the law,
Right.
go until some date in the future when the case is litigated. That's what the May 12th hearing will be about. The federal case, they have not filed such an injunction. Federal case is instead of being about state constitutional law, is much more focused on claims under the First Amendment. There's no preliminary injunction there. So my point of view is that, you know, we have no reason not to go forward with things as if there is no court action, or in other words, we need to just go forward, because there's no injunction in place. There's no impediment to us acting. Obviously, we act in, you know, advisedly on this stuff. But you know, there's really not a position. We're not really not. I mean, there's nothing that has occurred in any of these proceedings that has altered my sort of viewpoint on the timeline of what we're trying to accomplish. So, you know, like I said, you know, as we go forward, we're hoping to spend some time over the course, maybe hopefully starting next month, on starting to flesh out some of the regulatory issues, you know, have those discussions. We would have enough time over the course of that period of time to, you know, to have several, up, you know, 2 or even 3, if we could, 60-day comment periods, to make sure we get everybody a chance to weigh in on these things, those kinds of things. So that's the agenda that we have in front of us.
But the May 12th, that's just like, hi, here we are at court and
Well,
we're going to get to this in 2 months or.
Well, I mean, literally, Mr. Chairman, Commissioner Payton, literally, I believe, and James, correct me if I'm wrong, but literally after that argument, I believe that the court has 60 days to rule on the preliminary injunction. Typically, courts tend to rule fairly quickly on preliminary injunction preliminary injunctions, because the nature of the injunction is is your claim that you have some injury that's irreparably being some irreparable harm, right? Exactly as you said. So and then there's an appellate process that can be taken from an injunction. Either whether you win or lose an injunction, there's the procedural rules and statutes allow for an appeal from that. So, I mean, without getting into just purely speculating, that's kind of the best answer I can give. And if I don't know, James, if you have anything you want to add or correct me on there.
Good morning, everybody. Good morning, Commissioner Chairman Meyer and Commission members. No, what Mr. Collins just laid out is correct. After the May 12 hearing in the state court case, the matter will be deemed under advisement, which means the court then has 60 days under the Arizona Constitution and Arizona law to decide the application for preliminary injunction. Also, all the defendants in that state court case filed motions to dismiss as well. So those motions to dismiss also will be part of what the court in the state court action needs to decide.
There's going to be appeals and all that could drag on. Has the election, right?
I mean, excuse me, Mr. Chairman, Commissioner Payton, litigation. I mean, we have had cases that have gone on for decades. So I don't know that there's any. There's no answer. There's no other answer than yeah. That's part of the reason why, in my view, we'll continue to do our job until and unless somebody says you should stop.
Okay.
So,
Mr. Chairman,
Go ahead, Commissioner Kimball.
I have a brief question, Tom. And we touched on this a little bit last time. The $25,000 limit or floor for non-statewide candidates. Can you, using your historical knowledge, tell me who is likely to be affected by that? Is it any legislative candidates, maybe Tucson City Council, Phoenix City Council, Maricopa County Board of Supervisors, et cetera?
yeah, Mr. Chairman, Commissioner Kimball. So the way I would triage this out is we have not seen, for the most part, a big independent expenditure presence in Maricopa County supervisor races heretofore. The Maricopa County Board of Supervisors is, as the county changes and evolves, that would be one that there might actually be, because those districts are as big as congressional districts practically, right? So to reach voters, yeah, you're looking at that could be a place. And then in a city, a citywide, yeah. I mean, I think that I'm not sure how they set the floor per se, but I think that, in all likelihood, if there was a really contested, I mean, Tucson's interesting, right? I mean, just to really speak from my experience, Tucson's interesting because when those elections aren't contested, they're just not contested. And there's just, some candidates, right, incumbents don't even have to raise any money, right? So, it's hard to say. And in the legislative, similarly, if it's in the general election especially, but then in the primary, we saw last time where there's a real heated sort of factional battle on a primary, or then in the general where the races are close, those are the ones that I think you're going to see that higher spending level, whereas in an all red or all blue district without a primary, you're going to see very minimal investment. So, I think that, I guess what I'm trying to say is the facts on the ground that are going to drive spending are going to be, first of all, whether or not the candidates have, if the candidates are able to clear the field, right, that automatically lowers the amount of money that's spent. And then if the race is key for control of something, and that can be a primary election in the case of a board of supervisors, or it can be in legislature, obviously the handful of districts that decide what the district will be, that's going to be where there's going to be some.
Okay, thank you.
Okay. All right. Mr. Chairman, if I may, I was going to go ahead and move on to the next thing.
Please proceed.
Sorry. No. So we want to talk a little bit about transfer records, right? So this is going to be and one of the things the commission is charged with is making rules that provide for, what, details, what additional details in terms of how these records are kept are necessary. But the act is very straightforward and is very clear about, it's pretty prescriptive to begin with. So a transfer record is basically a written record of the identity of a person who contributed or transferred more than $2,500 of original monies for campaign media spending, the amount of the contribution or transfer, and the person to whom those monies were transferred. Those are records that the covered person is going to be collecting, and we'll talk a little more about how they do that in a minute. But they're going to keep those for 5 years, and they're going to have to provide them on request of the commission. Original monies, just to flesh this out, is business income or an individual person's income. So what does that mean? Basically, what this is a transactional history that shows you how you got from the original, how you document the original source of monies. It's essentially a receipt. These are not receipts that per se are part of the reports, right? These are records that are internal to the covered person, but they are the information from which we'll see they generate the actual reports that need to be filed. So we're going to go to the next slide. So if I'm a person and I donate more than $5,000 in traceable monies, which is to say monies that are going to be used for campaign media spending in an election cycle to a covered person, I have to inform the covered person in writing within 10 days after receiving a written request from the covered person. So now that's the way the statute's put together. And so it seems, so I'm using the language of the statute here in the slide, but essentially what that sets up is I'm a covered person and I got money from somebody else. I'm going to send the other person a request that says, tell me in writing the identity of any other person who contributed more than $2,500 of their own money to you that was transferred to me, and the amount that they gave. So if I am, covered person is ABC, group. They received a donation from XYZ. ABC asked XYZ, hey, you know, where did you get the $5,000 from? And then within 10 days of receiving that, they have to tell me, you know, who persons D, E, and F were, if they gave,
If any.
if any. Yeah, it is possible, obviously, that that person could be the original source.
I mean, Tom, quick question.
Sure.
So, I mean, under the act, I mean, it's the candidates are required to report this funding, right? So I guess how do you know if it's not reported? I mean, aren't we relying on that? Is there any way to, I mean, I guess there's like an enforcement concern I see with this.
Sure.
Am I missing something?
No, not at all. Mr. Chairman, that's right. I mean, so what we're trying to lay out here is how the transactions are going to work on the covered person side. Covered persons aren't candidates. They're entities other than candidate committees, because candidates are already required to disclose all the stuff they're required to disclose. Just a point of clarification.
Yeah, there's no disclosure obligation by the covered person. It's the candidate that has to disclose who the covered persons are, right?
No, let me back up a second. Covered person is the filer. So what this is basically, just to go back to the categories of expenditures that are covered by the filing. It's basically independent expenditures and ballot measures. Those are the two big ones. There's a couple, three other categories, but the big money, right? The big filers are going to be the IE groups. So this is a person who is acting not in coordination with a candidate, but who is spending money to get that candidate elected, and folks who are spending money to get a referendum or initiative passed. You know, those are the big buckets of covered people under the act. So they're going to have their obligation is to report what they spend, and we'll get into in the next couple of slides exactly what they're required to report. But the upshot is, just to preview, they're going to have to report their original sources of money. And so what we're trying to go through here, and maybe I should have ordered this a little bit differently, is I'm sorry. So does that answer your question, or am I missing?
I think so.
Okay. All right. Well, all right. Well, stop me if you, because I think within the next two slides, we'll get to the answer directly. Okay. So we got more documentation here. If the original monies were previously transferred, then the donor has to disclose the previous transfers of more than $2,500 and identify the intermediaries. Again, the idea here is that we're going to chain back transaction to transaction back to the original source of monies. That is the business income or the personal dollars that went into the original, that go into the end spender, right? So we have end spending that says vote for candidate, vote for candidate A. But back here, there's an original spender who the original source who gave money to ABC group, and then ABC group turned and gave money to XYZ group, and then XYZ group gave money to people for candidate A, right? So we're working backwards from the filer to the original source through their intermediaries, through the series of requests that are incumbent on the covered person to document where the money is coming from. So the change here from the 2016 and the current campaign finance law for most, but not all, independent spenders is you're not in a position to just take money from the XYZ group to candidate to people for candidate A group transaction. you can't just, that's not the end of it, right? You can't just say, I got money from this group and that's it. And that's all you're going to know. It goes a step back from that. That's sort of the framework here. If we could get to slide 6, I'm sorry. Can we get there? Oh, okay.
This is what Mike's going to be doing.
Yes. Okay. So that's what, so the scenario I just laid out is the original money is previously transferred, right? So that's, a person here gave to XYZ, or I should say ABC to XYZ, and then XYZ to candidate A, or people for candidate A, not candidate directly. People for candidate A go back to XYZ and they say, hey, tell me if there was a prior transfer and who you got that from and who the original source for that was. And then those records also need to be retained. So, and then just for definitional purposes, and when you have this later, I think this will be helpful. That there's that definition of traceable monies, which is basically monies that have been, given to a group to be used for campaign media spending, and the original source did not opt out. So I guess if we could try to go to slide 7. Yeah, okay. So this really gets to the chairman's point, like covered persons. Okay, so again, covered persons are the end filer, right? They're the filer. They're whether they're a PAC or some other form of corporate entity. These are the people who owe the reports, and this is what they're going to have to tell us, or tell the Secretary of State, and then we'll do the enforcement. They have to tell the identity of the person who owns, controls the traceable monies, right? So that means covered person tells us in the report the identity of the human being on their staff, or their agency or their consultant, who actually possesses the money that's set aside for campaign media spending. So if people for candidate A, friends of candidate A, whatever the group is called, or the group voters in favor of Proposition 500, that or entity has to identify somebody who is in charge of keeping track of their money. That's basically that's effectively their treasurer, but the statute doesn't use that term. Next, the identity of any entity established, financed, maintained, or controlled by the person who owns and controls the traceable monies, and that maintains its own transfer records and the entity's relationship. So what is that? That's if people for candidate A have additional organizations or subsidiaries under them, and they're transferring money out, who is responsible for that, and what is the relationship to the covered person? The next one will be the name or address and position of the person who decides how the traceable monies are spent. So that may be the treasurer, it might be the consultant, it might be the campaign manager for the IE group, right? It could be any of those people, whoever it is. We're going to need to know who that person is, and then the amount of traceable monies that are controlled by the covered person on the date the report is made. So that traceable monies, again, that's money that is set aside for campaign media spending. The donors of that money have not opted out. And so there's an amount of money. And the analogy here I would draw is to the traditional campaign finance system is, if you look at a PAC, a standard PAC, if you look at one of the reports, which I think you all have at times, it tells you what their cash on hand is. at the end of a quarter in a reporting period, it'll always tell you what the cash on hand is. And that's not a precise, I'm not intending this to be precise. This is for illustrative purposes, but that's basically what that is. So again, it's very similar to what is otherwise being reported for PACs now. How much cash do you have on hand that's set aside for campaign media spending? So not all their money, right? It doesn't mean all their money. It's very specifically doesn't mean all their money. So if a group has, $1 million in the bank, and the donor of $500,000 that said, I'm not interested in your campaign media spending aspect of your work, that's not information that we will have. So we will not, they will not have to report their total amount of dollars.
So what about if they're just helping to support the organism? That's not about the media, but so paying the bureaucrats doing that, whatever, in the primary or general.
Right. So yeah. So the act talks about there are certain kinds of expenses that go toward campaign media spending specifically that you would have to report. But if you're just a donor, keeping the office open or supporting, let's say you have a 501c3 that sponsors an initiative, but also has a range of public policy programs focused on enhancing child welfare, for example. So you're running an initiative to raise the tobacco tax to fund child programs at the state level, but you also run a policy program and you train people and you do all that other stuff. The act says that if your donors for that stuff say they don't want their money used for campaign media spending, they're off the table. Okay. If we could go to the next slide, I think it's 8 maybe, or 9, or well, I think my number is backwards. The identity of each donor of original monies. Okay, so here we get into, and this is where we get into why we have all these transfer records, right? Why are we asking? Why is Prop 211 asking the covered person to understand where the money they're receiving is coming from? And that's because on this report, we're asking them, or the Prop 211 is asking them to identify each donor of original monies who contributed more than $5,000 of traceable monies or made an in-kind contribution during the election cycle, and the date and amount of each donor's contribution. So that is, again, on a traditional campaign finance report for a traditional political action committee, that is standard. That's the standard contribution schedule that you would see for any PAC. Now, difference here. This is to just bring this together. This is for spending at a certain scale, right? So in the context, if I run a PAC, just an ordinary PAC right now, I've got 200, and let's say I give the it's an independent expenditure PAC, and I Tom Collins writes them a check for $300. That's going to be reported as a contribution. But for these trigger reports, these have to do with bigger spending than it. So we're looking for more than $5,000 contributions, right? So that's a significant, that creates that's a significant point, because what that says is that this act is focused on people who are donating, more than $5,000. So very much not your mom and pop person, not me writing a check.
State legislature.
Right. Yeah, exactly. The average just to give you context, the average donation to a candidate for the state legislature is like $200 or somewhere in there, $180 to $200, something like that. So, right. So that person, this is not going after, although they may have to report under other laws, that this act is not focused on those folks. And then again, then we get into then we have the next thing we talked about in the transfer record. We talked about the intermediary. So we want to know who the intermediary is, right? So when people for Canada Day made the spend. We want to know that XYZ, the XYZ fund was an intermediary for the ABC fund. And then this last bullet point on this page is, again, to put this in the context of any standard campaign finance report, except scale, right? It's what do you spend the money on? Which again, we require under the Clean Elections Act, that it's required under the standard campaign finance report, except, and again, this is the important thing here, we're looking for a big expenditure. You were looking for a $10,000 expenditure before you have to, in this report, so again, not the $5 lunch reimbursement that you got for stopping at the gas station, kind of thing. Well, to get a hot dog, not to get gas.
That's not even.
Well, fair. I don't know. Showing my age already.
Yeah.
Back in my day, gas was under $1 when I graduated college. It was.
All right, page 10.
Okay. All right. Okay. So these are just, and this is just continuing with the report, the identity of any person who received 10,000 or more from the covered person. That's that. I think that's I think I repeated myself there. And then finally, identity of any person whose total contributions and traceable monies to the covered person constituted more than half the traceable monies of the covered person at the start of the election cycle. So basically, we're looking for if you have a donor who contributed more than 50% of your money, that would get reported. So, all right, we're gonna go over the exceptions real quick, and then we'll go back to tying them together. I think that'll work. But so I hope, Mr. Chairman, specifically, because I want to put this back because your question was a good one. What we're building towards is, a covered person has to file a report. They have to know where they got their money in order to fulfill the requirements of the report. They need to know who their original sources are, and they need to know who their intermediaries are, and they need to know who they spent their money with. Those are the three pieces of information that are really the bulk of the thing. We also need to know who's the contact person, right? And that, to your point about enforcement, that's part of the enforcement aspect of this, right? We're asking to know, enough about this organization that we would have a contact place to work with, to work with an organization. If we had an issue, as we've talked about before, we tend to work with folks on compliance. So that's it. So basically, we want to know at the minimum contact information, who's responsible for the money, and then that group is obligated to be able to accurately file with the Secretary of State a report that says who they got their money from and who acted as an intermediary for the process of getting those dollars that are above $5,000. So I want to touch on the exceptions really quickly because I think they're important, and then we'll kind of wrap up this section. Exceptions: the identity of an original source that is otherwise protected from disclosure by law or a court order shall not be disclosed or included in a disclaimer. So, there are a number of different laws, and I don't think we're going to try to identify every law that could apply, but if a person knows that there's a law that protects their identity, and they're also, in this $5,000, upwards of $5,000 range, that will be a thing, something that they would be able to take advantage of. The one that sort of seems to stand out here would be there are certain addresses and identities that are protected already, in state law for purposes of donation. Those would be the kind of folks we would be looking at. Whether or not any of those folks are given $5,000 or more, I don't know, but that's what this is getting at. Or a court order. So if you've gone to court in some capacity to say, I have an interest that needs to be protected here, and my privacy is established by a court order, that's another way. Now, importantly, that the person who thinks their information ought not be disclosed can file something with the commission that says that there's a reasonable probability they have a reasonable probability that public knowledge of their identity would subject them or their family to serious risk of physical harm. So that's an area in which we will have to have a process to deal with those things. But there is, but there will be an option for folks who believe they're in that position to file something with the commission, and the commission will have to make a decision on that. And then finally, and this is really important, if you're an original source and you're under that $5,000, if you're $5,000 or less, altogether, you're not going to get disclosed. So that's kind of a safe harbor that's in the statute. Okay, thank you. So here's where this kind of all comes together. The transfer information has to be provided to the covered person upon that person's request. So if I want to be involved in financing campaigns in Arizona, I need to be prepared to provide to the end spender the information about where I got my money under the, at those thresholds that are set forth. And then for reporting purpose, then the covered person is going to use those reports to determine the sources, the intermediaries, and the amounts of, it should be direct or indirect, contributions received. And they're going to be able to rely upon that documentation. That's their protection, is that documentation, unless they have some reason to know the information is false or unreliable. So again, to get back to Chairman Meyer's question, for enforcement purposes, the theory is here that yes, you can rely on the information that you're receiving from your intermediaries or your funders, unless you can't, and that should be, if all the things being equal, everybody is so what do we know? We know that everybody who's an original source had the option to opt out, right? So those people are given knowledge that their money could be used for campaign media spending. So they have knowledge. The transfer organizations are on notice that they're required to provide accurate information to the covered person on request. They have that notice. And then the covered person has the protection of, provided they're asking the questions at the appropriate time and filing their reports and getting the information from any intermediaries, that they can rely on that information. So what that means is, as a practical matter, first of all, we're talking about thresholds that are higher than many of the existing thresholds where names are revealed under current state law for all kinds of different purposes. Talking about higher thresholds, we're talking about direct communication to the source that confirms, yes, I know this money can be used for campaign media spending, and thus I can be, I could be revealed as a source of funding, right? So that's a layer that you may get with a PAC, but you may not. I mean, I'm not sure that everyone's aware that if you write a check to a PAC for $300, you're going to be on on a campaign finance report, but this has that locked in. We have a process for that, right? So there's actual notice. The transfer is made aware of their obligations, and they have to, maintain that relationship with the covered person. And then the covered person gets, again, they get the benefit of these thresholds that are high before they have to file these reports. And they also get to rely on that information. So everybody in the process has a form of, direct notice, either through the requests or the opt out, and the way that the process works. In other words, everybody at every layer is informing everybody at every layer about what their obligations are under the law, in addition to the law itself, which is we're all, bound by. So I don't know, Mr. Chairman, does that kind of help a little with the?
I think so.
Well, I mean, we're going to go back over this again and again. This is not, I mean, the plan here at this point, and this was, I got to give Commissioner Kimball credit for sort of, suggesting we do this, because I think it's been very helpful, because I find, it's something you got to go over again and again. It gets simpler every time you go over it. I swear. So if we could go, thanks, Kathy. So, and this is just an example. This is a report, an actual report from the City of Phoenix's dark money ordinance. Now, is this exactly what ours will look like? Maybe not, but you can see there again, you've got the name of the covered person, right? That's the name that's under person, association, or entity reporting. You've got the expenditure information about who the vendor is. You've got the amount they got paid. You've got the candidate that they spent on and what the race was for and the date of the expenditure. So then we've got an original source information. So we've got this in this case, it's right. So we have a PAC that was paid, that was given a donation by a union, and then their vendor is a different union. So, but that's the original source. We get the amount and date of their donation. And then we have, in this particular case, we don't have an intermediary, but we would have one if we did have one. So if AFSCME had given money to, or if the Foundation for Good Stuff had given money to AFSCME, that would show up at whoever the intermediary would show up there. So that's sort of the most concrete way to sort of start to see how these things get tied together. So what we've shown today, what we tried to show is, how do you get, and maybe, if I do this again, maybe I'll reverse these slides and do it from the back end up, but how do you build the report from the intermediary to the original to the expenditure information? How do you build that up? Who's obligated to provide information that ultimately gets you to a report that looks something like this?
Pretty explanatory.
Yeah. I think the form, once you get there, it kind of makes some sense, but otherwise you wouldn't know what to. I also wanted to just note, and this is just just because we're using somebody else's form here as an example, for our frequency for the Voter Right to Know Act, the first $50,000 or more statewide is a trigger, and then subsequently every 25,000, and then for the lower level campaigns 25,000, and then every 15,000. Okay, so these are a couple of important points that are separate, but I felt like they fit here better than in the next presentation, which is going to be more focused on, enforcement and those kinds of things. First, we talked about PACs and parties, and, those, those folks are still going to have filing obligations under the, traditional existing campaign finance code. However, and so the Voter Right to Know Act handles those folks in two ways. First, it says, look, you've got a schedule for filing these on a quarterly basis throughout the election year. That's fine. Stick with that, and you don't have to file the reports at the frequency of the VRKA, except you do have to be able to tell us at least as much information as we would have had. So in other words, on a PAC report right now, you have Schedule C for contributions that has all the contributions. If I was writing the programming for this, I would add in a schedule. I guess I don't know how many schedules there are. Like, let's just say Schedule X for the to make sure that there's a highlight for the Voter Right to Know Act disclosures required of the PAC or party. So basically they get to keep the same schedule. They get to keep the same schedule for filing, and then there's basically an additional box, 2 additional boxes on the report for Voter Right to Know Act information. And then, the one difference is, though, that PACs and parties, when they get into the last 20 days of an election, they're going to have to file the other report. There is an additional reporting requirement imposed on PACs and parties that right now, they have to file a pre-general report and a post-general report. This creates an interstitial trigger report that says, hey, as we go into the last 3 weeks of the election, you've got to tell us what you're doing if you get over those thresholds.
So do they need to do one for the primary and one for the general?
Right now, they do that anyways. This means that this would mean that every 50,000 or every 50 or $25,000, and then every $25,000 and $15,000 during the last 3 weeks would require a new report. All right. I know this is a lot of dense stuff, but I appreciate everybody's patience.
So Tom, how do you value the in-kind contributions? I mean, is there always a way to do that? I mean, if someone donates their home for an event, I mean, how do you know if that's worth?
Well,
How do you know if that's worth $4,500 or $5,500? I mean,
well, the way we do that is, I mean, there's a couple of different ways we could. Typically, for the most part, what we have done in the Clean Elections Act context is we take an assumption that the first assumption is the person's going to file something that's in the nature of good faith market value. Instead, the in-kind is basically requires, I mean, there's all the definitions of in-kind, whether they're campaign finance or tax, basically require something like market value. So the first assumption we don't assume people are going to lie or mislead on the form. So first stab is, does this seem like it's reasonable? If it's not, or if we have reason to believe there was an in-kind donation that was not reported, then what we typically do, and we've done this before, is we will do an assessment of the market value for that space. So, for example, it's pretty easy to do that now because so many different things are commodified. But an example would be if you used an office space for a fundraiser, right? We might not be able to get the value of that space for that period of time from the person who provided it, but because of Regis and WeWork and all these different companies, we can now get a pretty good idea of what the going rate for event spaces are for that kind of stuff. And the other thing we've also done in the past is contact different vendors, and talk and ask them, if we can get a sense of what the market rate for a vendor is. Now, that's sort of our approach. And then typically, in an enforcement case, there's some back and forth about, what that should be, you know, and that's, you know, sort of where the, you know, that's something that we then, you know, subject to some discussion, and eventually, if we have a good faith market-based basis for believing that something was underreported, we would have a complaint in front of the commission, and the commission would have to make a judgment about whether or not, you know, if there was a recommendation, you know, that the market rate was X, and the other group says it's half of X, you know, they have to make a choice about that.
All right, thank you. Is that the conclusion of that, Tom?
I've got one more page, 2 more pages, but one real page and then one more technical page. So I just really wanted to hit, because there's no other place to put it really, is this disclaimer requirement. So everybody knows, you get a mailer, it says paid for by so-and-so, not authorized by a candidate, or paid for by the candidate and authorized by the candidate, you know, that kind of information. And if it's a PAC in Arizona right now, you also get some information about the top 3 donors and whether or not they're in state or out of state. So this would cover those kinds of situations, and it wants us to have the top 3 donors of campaign media spending. And now there is still a political action committee definition that people can choose. Essentially, if they apply with this, they don't have to comply with 16925. We haven't worked out yet if they comply with 16925, whether they have to comply with this. But the idea is that there's not a redundancy with the 16925 requirement for PAC specifically. The difference between the disclaimers here and the PAC disclaimer is the PAC disclaimer is a PAC disclaimer. So right now, there are entities that spend in elections that are not PACs, that aren't putting on their mailers their top 3 donors. This broadens that. So it says, doesn't matter if you're a PAC or some other form of entity that makes, for example, does express advocacy for and against candidates, you're going to have to put something about your top 3 donors. And then if you're doing it by text, the next page is, and this is the last page, if you're doing it by text or something like that, you got to have something on there that points you to a website that tells you, you know, here's who our donors are. And again, those are not different in kind or even really degree from the kind of information that other folks who are spending in elections are obligated to follow in the first place. So there's really no, again, I just want to reiterate that essentially, if the current campaign finance system is, and by all accounts it is acceptable, it can't become unacceptable by just requiring the same things, you know what I mean, except at sort of higher levels and with a little bit different, some different nuances. But the upshot is that this is a reaffirmation of many of the principles that are grounded in the Constitution and the campaign finance law, and not some kind of radical departure from certainly the laws it was prior to 2016 in Arizona. So that's the end of that presentation. I really appreciate you all bearing with me on this, but I think it was a good idea to try to start to tear into this, and we'll continue to try to answer questions. And if you have questions as we're going along, even if for some reason, and I can't imagine you'd be doing this, but you were sitting at home and you're like, I think I want to leaf through the Voters' Right to Know Act, we are available. Mike is certainly available. So In fact, I think you should definitely call Mike first. But in any event, that's our presentation, and thank you very much to everybody for listening.
Thank you, Tom. I agree. It is important that we go over these things and, learn them no matter how detailed they are. And I appreciate you putting that together for us. Do any other commissioners have questions for Tom on that presentation or any other issues on Prop 211? Okay, hearing none, we will go on to agenda item number 6, which is discussion and possible action on termination of rulemaking regarding proposed amendments to R220-211 related to subpoenas. Last month in the executive director's report, Tom gave us an update on the status of the governor's regulatory review council's deliberations over a proposed rule. The memo in your materials outlines the results of those hearings. Tom's recommending that we terminate the rulemaking regarding those proposed amendments. Do any commissioners have any questions for Tom on this issue? Excuse me.
Bless you.
I did not get the mute button hit in time. I apologize.
We're not on the radio.
Any questions for Tom on the recommendation that we terminate this rulemaking?
I have a question, Mr. Chairman.
Go ahead, Commissioner Chan.
Tom, I guess I just want to understand what the ramifications are of terminating the rulemaking, because I mean, we obviously promulgated the rules to address things that were important to the commission's business. And now we're terminating, and I'm curious if does this mean we have to just kind of put these issues to bed and not do any rulemaking? Are we going to take another bite at the apple? Do we have any thoughts on that, or
Sure,
a game
sure.
plan?
No, yes, Mr. Chairman, Commissioner Chan. Yeah, I mean, what we try to say in the memo is basically, look, for the time being, this is kind of a not worth pursuing under this particular effort. In other words, since we filed this with GERC, we've gotten some new case law. We are working through the issues with Prop 211, and so so I do think that we will have a number of different broader issues regarding enforcement procedures that we're going to want to look at in view of developments since this particular rule package went in front of GERC. And so we may very well want to revisit that at that time. And I think what we want to do at this point, given where the council is, at least at this moment in time, and given where we do have to look at some of these issues from a lens of Prop 211, which recall when when we promulgated this, Prop 211 was not on the table. In other words, we didn't know if it was going to pass. We certainly weren't going to delay or change our calendar around speculating about whether or not it would or wouldn't, or what that effect would be, if that makes any sense. So, but now we are in the place where we have some new cases to evaluate, and we have some new law that we want to, if we can, show that we're lining up, because we now have the clean election. We now enforce, in effect, two different laws, the Clean Elections Act and the Voters' Right to Know Act. They're different chapters. They have different responsibilities, but given for staff convenience, for the convenience of stakeholders, especially in their costs, we want to, I think, in view of all this, want to be able to have procedures that don't switch on and off depending upon what law you're under. It would be we would like to end up, ideally, if possible, in a place where the rules for the Clean Elections Act enforcements, to the extent we have them, whether they be against clean candidates or independent spenders, or in the off chance when we do have a traditional candidate who has violated the Clean Elections Act and other people who violate the Clean Elections Act, we would like to have those rules be as consistent as possible with what we end up coming up with Prop 211. And then we also obviously have, like I said, this this case law developments that are sort of ongoing in terms of how administrative enforcements are gonna work. So we want to take advantage of whatever opportunity there is here to learn that, and ultimately end up with a more holistic approach to this, that so anybody who comes in the door at Clean Elections knows what, at the agency Clean Elections, knows what they're looking at, knows that, knows what differences there are, if any, and knows that, knows what to expect. As I said, this was this at the time we had a different set of circumstances and a different set of information regarding what we might have what might happen with the Attorney General's office. And if we end up with a conflict with the Attorney General's office on something that relates to enforcement, this comes to a head, we'll just have to deal with it, which is what we would have done if we hadn't had the rule fixed in the first place. So it's not an insurmountable problem. This was I think from my perspective, this was a good choice, and the reason we recommended it was a good choice under the circumstances we faced to have this clarification, to make sure that, at least with respect to our relationship with the AGO, things were clear. But so many circumstances changed between October of 2022 and basically March of 2023. Now, GERC's opposition to this rule was, as the memo talks about, it's a little hard. They don't have to reduce their reasoning to one. They're not a court. They don't reduce their reasoning to like one set of reasons that they agree on. And so sometimes it's a little hard to understand what precisely they mean. And the memo uses two examples. One, Jenna Bentley, who's a council member and also, works for the Goldwater Institute. Her point of view was that, and again, our Kara's and Kyle's brief and the staff attorney from GERC disagreed with this, but her point of view was this pre-New Deal case from, I can't remember, 1930 something, that was not a constitutional case, but that took a hard line on one particular agency's ability to subpoena, was literally the law. There's no other law, no other case matters. That's it. That was her view. So her point of view was essentially, it is per se illegal for any agency to delegate anything, unless they have some kind of like super duper, absolutely, like explicit, beyond any shadow of a doubt, delegation, that authority, that that was something along the lines of like a commandment. Commissioner Sant, Councilmember Sant rather, he was a little bit less maybe less clear, but he sort of said, I don't like, and I use the word like because that's what the word he used. He said he didn't like the fact that the rule allowed if the executive director delegated, that the person who was delegated to do the subpoena could delegate it to another person, and he felt like that was he didn't ever articulate any legal reason why he believed that was impermissible. He simply said he didn't like it. So, is 6-1 vote? I mean, these are all council members who, like us, who have been on the council for a long time. You never know what's going to come up. The public comments, and I know this may be going past what you need for an answer, Commissioner Chan, but the public comments that they got were interesting because they must have been driven by some kind of email campaign to generate them, right? Because ordinarily, at least in my experience, state agencies don't get 145 pages of comments on a Sunday just because. And they all kept talking about Prop 211. They repeatedly kept talking about Prop 211, and now Prop 211 is not popular among certain segments of the population. But the fact that there was a conflation there of these two issues, to me, led me to conclude that there was kind of there was something, the council's entitled to make his decisions, but clearly somebody outside the council believed there was a point to score here. Otherwise, they wouldn't have bothered to get their folks to inundate the council with these comments that really weren't on point. So for all those reasons, the environment there, wanting to take a holistic look at where we are, including Prop 211, and then the circumstances that have changed since October of 2022, that's our intention, and that's what we try to capture in the memo. That we're basically there's no purpose in putting in sort of rewriting this right now if we're going to have to do a whole bunch of stuff as we are to set forth how the enforcement process will work under Prop 211, and then if we want that to also catch up with what we do under clean elections. So.
So Tom, if I can sort of summarize what you said, I mean, we're talking about Title II here, which is compliance and enforcement procedures.
Yeah.
We're gonna have to rework a lot of that based upon Prop 211. So this change that we made in R220 211 last October is probably going to have to be modified again anyway as a result of Prop 211. So it's really not worth having this fight right now over something that we're going to have to amend anyway. Is that a fair summary?
Yes, absolutely.
Okay. All right. Does anyone else have any other questions for Tom on this issue? Is there a motion to terminate the rulemaking regarding amendments to R2-20-211?
Mr. Chairman,
Go ahead, Mr. Kimball.
I move that we terminate rulemaking regarding proposed amendments to R2-20-211 related to subpoenas.
Is there a second?
I'll second that.
All right, we have a motion and it's been seconded. Motion to terminate the rulemaking regarding amendments to R2-20-211. We'll go ahead and vote, and I'll call the roll. I'll start with Commissioner Kimball,
Aye.
Commissioner Payton,
Aye.
Commissioner Chan,
Aye.
Commissioner Titla.
Aye.
This is and Commissioner Meyer, I vote aye as well. Motion passes unanimously to terminate the rulemaking. And Tom, I think you provided a form in here, your packet that accomplishes that. Anything else that we need to know about that, or you need from us on that form?
No, thank you. Thank you, commissioners.
All right. Okay, on to agenda item number 7, which is discussion and possible action on the 2023 chairperson. As you all know, every year the commission elects a chairperson to chair meetings for the calendar year. I'd like to have a discussion about who feels comfortable taking on this responsibility for the rest of 2023, and hopefully we can resolve that here today. Discussion on chairperson duties moving forward. And Tom, I think we kind of rotate this. And if we did do the rotation, who would be next in the rotation? Is it Commissioner Kimball?
Let's see. You were appointed, and then you were appointed, and then I think that's right. I believe that's correct. I mean, I think we skipped when we got to you. I think we skipped having Commissioner Titla come back again, and so I don't know if he. But yes, that's right, because you were Governor Brewer and you were Senator Hobbs and you were Governor Ducey and you were Senator Hobbs and Commissioner Titla was Senator Landrum Taylor. So that's right.
Well, I guess let me ask, do any of my fellow commissioners want to lobby for this position? Yeah, wow, I don't hear anyone out there banging the drum. Okay, is anyone willing to take on this position? Commissioner,
Mr. Chair-
Commissioner
Mr. Chairman.
Payton? Go ahead, Commissioner Kimball.
I don't want to lobby for it, but I'm willing to do it if it's my turn.
Okay. Anyone else have any comments on serving as commissioner?
Mr. Chairman, can I move that we elect Commissioner Kimball to be our new chairman for the year? Is it too early to do that?
Unless anyone else has any further comments, I am fine with the motion. Does anyone else have any other comments? I'll table Commissioner Chan's motion for a moment. Does anyone else have any further comments on the chairman position? Okay. If not, we have a motion from Commissioner Chan to elect or designate Commissioner Kimball as the commissioner for the remainder of 2023. Is there a second to that motion?
I'll second that.
All right, Commissioner Payton seconds it. All right, we have a motion to appoint Commissioner Kimball as commissioner for the remainder of 2023, and it's been seconded. Go ahead and call the roll. Commissioner Chan, how do you vote?
I vote aye.
Commissioner Titla,
Aye.
Commissioner Payton,
Aye.
Commissioner Kimball.
I think I'll abstain, Mr. Chairman.
Thank you. And then I will vote aye as well. So the motion carries 4-0 with one abstention. Congratulations, Commissioner Kimball. I am passing you the virtual baton here. With that, we'll move on to public comment, which is item number 8 on the agenda. This is the time for consideration of comments and suggestions from the public. Action taken as a result of public comment will be limited to directing staff to study the matter or rescheduling the matter for further consideration and decision at a later date or responding to criticism. Please limit your comment to no more than 2 minutes. Does any member of the public wish to make comments at this time? And if there's anyone on Zoom, please raise your hand or let us know. Unmute your camera and your microphone and tell us. And also, the public may send comments to the commission by mail or email at ccec@azcleanelections.gov. Is there any member of the public there in the meeting room, Commissioner? I'm sorry, Tom?
No one wants to make any comment.
Okay, anyone online wanting to make a comment? All right. So there is no one there for public comments, and at this time, item number 9, motion to adjourn. At this time, in my perhaps last act as chairperson, but who knows where we'll be 5 years from now. I would entertain a motion to adjourn.
Mr. Chairman.
I motion.
I'm sorry, Commissioner Titla? Did you make a motion
Motion to adjourn.
All right, Commissioner Titler has made a motion to adjourn. Is there a second?
Commissioner Kimball, I second.
All right, we'll vote and call the roll. Commissioner Payton,
Aye.
Commissioner Kimball,
Aye.
Commissioner Titla,
Aye.
Commissioner Chan,
Aye.
and Commissioner Meyer. I vote aye as well. We are adjourned. Thank you, everybody.